Another set of cases which can be brought before the case under its original jurisdiction relate to relief, compensation or restitution of property, which is under Section 15 of the National Green Tribunal Act. So for victims of pollution and other environmental damage, they can approach the Green Tribunal seeking compensation or for restoration of their damaged property or for restitution of damage to the environment. Now, application for relief and compensation and restitution of property has to be brought before the tribunal within 5 years from the date on which the cause of such compensation arose. Now, the reason, and again, like in the case of the earlier case that I discussed, there's a grace period for 60 days granted. But I must stop here to explain why this time limit is 5 years. It's 5 years because there have been cases where industrial accidents have occurred, but the impact of the industrial accident, such as the health impact, has only been noticed or has only arisen much later. And an example of that could be the Bhopal gas tragedy, where victims of the gas tragedy came to know of health impacts much later. So such victims of pollution and industrial disasters actually have a much longer time to bring a case to court for compensation. They can come to court within 5 years from the date on which they actually come to know that they have been adversely affected by a particular activity or an industrial accident. Now, the kind of orders that the NGT can grant in such cases, it can direct restoration of the damaged environment. So, for example, it can tell a company to install sewage treatment plant to clean up a water body, to clean up the river, or it can direct compensation to be paid to victims of pollution, or it can direct restitution of damaged property. Now, we move to the second type of jurisdiction of the National Green Tribunal, which is the appellate jurisdiction under Section 16 of the National Green Tribunal Act. The appellate jurisdiction, as I mentioned earlier, involves challenging an order previously given by the government, and it can be done with regard to any of the 7 laws that I mentioned before. And I'd like to give certain examples of the kinds of orders that may be appealed against before the National Green Tribunal. For example, the environmental clearance that is granted under the EI notification of 2006, the forest clearance that may be granted under the Forest Conservation Act of 1980, or the consents to establish and operate that are granted by the State Pollution Control Board under the Water Act and the Air Act. These are 4 types of approvals or consents that are granted by these regulatory authorities under these 4 laws. If these are granted and people are not happy or are affected by these clearances, people can challenge the decision to grant the clearance. On the other hand, if the clearance has been denied or the consent has been denied, the industry which approached the government for such a clearance can approach the National Green Tribunal to challenge the decision of the concerned government agency. With regard to the appellate jurisdiction of the National Green Tribunal, the National Green Tribunal can be approached within 30 days from the date on which the order or decision that is being challenged has been communicated to the people. Beyond the 30 days, there's additional 60 days that is permissible, but only if the petitioner is able to convince the tribunal that there was a sufficient cause or reason for the delay in approaching the tribunal. The next question that comes to mind is who can actually approach the National Green Tribunal, or what is called in the legal parlance the locus standi, who has the standing. Before the tribunal, in fact, it is an extremely broad rule. Anyone literally can approach the National Green Tribunal. It can be an individual, it can be a company, a firm, a non-governmental organization, need not be registered. It could be a government agency, so for example, a municipal corporation or the State Pollution Control Board. Any person or entity can approach the National Green Tribunal as long as it is not frivolous and malicious litigation. Also, I must point out that the National Green Tribunal has adopted a liberal approach in understanding that persons do not have to be directly affected by a project or an order to approach the National Green Tribunal. Even if any citizen of this country living in Delhi is interested or wants to challenge a project which has been granted in the state of Arunachal Pradesh, the citizen can do so, because the Green Tribunal has held repeatedly that it is the fundamental duty of every citizen of this India under the Constitution to protect the environment, and therefore if a citizen is based somewhere else and is not in close proximity of the particular project, he or she may still be concerned with regard to the environment and have the right to approach the National Green Tribunal. Now, what are the kinds of directions or remedies that can be sought with regard to from the National Green Tribunal with regard to its appellate jurisdiction? The National Green Tribunal, if it finds that a consent or a clearance has been given illegally or the process has not been followed properly, can cancel a clearance or a consent, or it can even issue a stay order or a stop work order, which means that no further action can be taken at that particular project site or industrial plant until further reconsideration. They can also they can of course reject an appeal before it and say that it doesn't have any merit, or they can ask governmental agencies to reconsider or reassess the situation. Unlike other courts in India, the National Green Tribunal actually has a time-bound requirement within a time limit within which it is supposed to decide. According to the National Green Tribunal Act, it must be the endeavor to dispose of the tribunal to dispose of applications within 6 months. However, it does sometimes take longer than 6 months because every party has to be given a proper opportunity to make representations. There could be certain inspections that have to be undertaken which are time consuming. So occasionally it does take longer than 6 months to decide cases. However, it's important to remember the Green Tribunal is still under a statutory requirement to try and decide cases within 6 months, because very often environmental cases are time sensitive, and if they are not decided, irreversible damage could be done to the environment and to the lives and livelihoods of people. The National Green Tribunal has all the powers of a civil court. Therefore, it means it has the power to summon witnesses, to require documents to be presented, to examine witnesses and such other things. It also has the power to give suo motu directions, which means that even if no party has approached it, it can give certain directions. However, I must point out that this power of the National Green Tribunal has been challenged before the High Courts and has not been decided as yet. The National Green Tribunal is not bound by procedure. So if you may have heard of the Criminal Procedure Code, the Code of Criminal Procedure, the Code of Civil Procedure, the Indian Evidence Act, these three form the core procedural law that governs Indian courts. The National Green Tribunal is not bound by them. The National Green Tribunal has been deliberately given the power to be innovative, to be able to come to effective conclusions in environmental cases. However, it has to be guided by the principles of natural justice. Its decisions have to be guided by the three important principles of environmental jurisprudence that the Indian Supreme Court has often referred to, which is the principle of sustainable development, the polluter pays principle, and precautionary principle. In cases of accidents and claims for compensation, the National Green Tribunal is required to adopt the no-fault principle of liability. Now, the penalty for not complying with the order of the tribunal is the following. So, if any person is directed by the tribunal to undertake certain measures and he or she does not do so, it could lead to 3 years of imprisonment and or up to a fine of 10 crore rupees. Now, in case of a company, this fine could actually go up to 25 crore rupees, and in case a violation continues even after a penalty order has been issued, additional per day fine for this continuing offence is also provided for in the National Green Tribunal Act. Finally, an appeal against the decision of the National Green Tribunal lies directly to the Supreme Court of India, which has to be made within 90 days from the date of the tribunal's order. However, if the appeal is not made within 90 days but made after that, the Supreme Court would have to be convinced for the reasons for delay. I just want to emphasize here that an appeal against the National Green Tribunal cannot be filed in the High Court. However, writ petitions can be filed before the High Court and Supreme Court under different constitutional provisions which are not restricted in any way by the National Green Tribunal Act or the functioning of the National Green Tribunal.